Good evening to everybody in India. Good morning in other parts of the world, western part, and the late evening on the eastern hemisphere. Very quickly, thank you so much. I'm so much overwhelmed by all the scholars around me and who have contributed generously to the book. And also the response that we have received. We have almost 600 registrations and a few hundred already were joining, and therefore we delayed the whole program by 5 minutes. Apologies for that. And I'm really happy that a lot of my colleagues and my friends and everybody around, I think, have conferred on me so much of honor, respect, love, and affection in their work. I've gone through the book and I can see it's such a great work done. I think I cannot imagine, and it's wonderful. I'll be talking a little later because there are a lot of people who need to talk. So today, I think idea is to introduce the book and the authors. And in fact, I should not forget to say that our sympathies go out for those people who are trapped in them in the pandemic, and it's a very sad thing. And we hope they all recover very fast. And on the other hand, I think every crisis brings us an opportunity. And the first thing I'm experiencing, if you ask me, is thank you. So I'm experiencing here in Mumbai is that in ocean in front of our house, we can see dolphins. Just a little while away, we see all the peacocks dancing. We've seen some deers on the Jew beach, and all the all the different birds seeing. The whole environment has become so cleaner. I think if we can continue with this pandemic and a not pandemic, but I would say lockdown, even voluntarily for ever, I think we'll be much better in many ways. So, of course, as a firm, we have decided to be virtual, 80% uh, from home and 20% from house. If we can save out of 100 cars, 20 cars not coming to the office, 80 cars not coming to the office, you can imagine how much pollution will be, removing from the life. Anyway, I don't want to go too long, but the work that has gone in is fabulous, fabulous. And I'm not going to preempt everything right now, but I would like to ask Dhruv, who has been the architect, and he created this idea of a book in a celebration of my 70th birthday. I'm not that old, by the way, but I think it feels very good. And I'm so much really overwhelmed by the kind of contribution all of you have made. And we'll continue our interaction. What we thought that this book, while you will read over a period of time, but if we can take chapter by chapter, give some explanation. So all the scholars and the authors who have contributed to the book, they can talk about their paper, their ideas, the thinking, and we can have good time for interaction. So we extended the whole celebration over a period of 2 weeks. And today, of course, is the inaugural thing. So we'll have a little briefing on the book, like orientation course when you enter the university. But at the same time, from tomorrow or day after tomorrow, every alternate day, I think we have these sessions. And in about 6 or 7 sessions, we'll have at least every time two authors will contribute, and then we'll have some interaction. So every second day we'll have an hour spent together. We'll learn a lot. I'm sure you'll enjoy this international tax series that we have launched. I really appreciate your coming on board. Thank you. So over to you, Dhruv, and just let's have a very nice evening today. Thank you.
Thank you very much, Nishith Desai. Well, my job today is just to introduce the book, and thereafter we will have a small talk by Mr. Arvind Datar. And then we'll have a short introduction by all the authors. But just generally, a lot of people have asked me, what exactly is a Liber Amicorum? A Liber Amicorum is Latin for a book offered by friends in honor of somebody who is eminent and somebody who's made a great contribution to a particular field. And the honor of being presented by Libri Amicorum is usually reserved for academics. And whilst Nishith Desai may not hold a professorial chair at a university, his contribution to and influence over the study of international tax law and policy, I don't think has been any less than that of an academic. As Nishith Bhai said, he turned 70 on 10th March 2020. It was only fitting that we present him with this Liber Amicorum with all our esteem and affection. Nishith Bhai has been a true pioneer in the field of international tax law. Not only did he run a pioneering practice of international taxation in India, but his research output has also been responsible for the dissemination of knowledge through a large body of literature that he and his associates have generated over the years. His initiation of private research in the field, conducted either by himself or under his tutelage at his law firm, have been instrumental in the careers of several prominent practitioners and academics that have emerged from India. Not only has he trained or mentored many international tax scholars, he has also inspired his peers and those who did not have the privilege of working with him directly. It would be no overstatement, therefore, to call him the father of international taxation in India. International taxation as a subject may seem like a niche in itself to many, but much like Nishith Bhai's personality, it too has become multifaceted over the years. The essays contained in this volume, Liber Amicorum Nishith Desai, reflect this and fall under four broad categories: tax treaties, digital economy, anti-avoidance, and a catch-all subject of tax policy. Nishith Bhai has always believed in sharing knowledge, and whilst these essays have indeed been written in his honor, one hopes that this volume does go on to inspire many more to take up the study of international tax law and policy. We were going to present this volume to Mr. Desai in a private ceremony, a conference that we had organized in Alibag on the 14th of March, but because of COVID-19, we were unable to go through with it. And true to his nature, Nishith Bhai innovated with the WebEx program and invited us all to share our ideas and the crux of what we've written about in our chapters over a 2-week period. So thank you again very much, Nishith Bhai, for everything that you've done for international taxation as a subject in India. And we're very grateful for the opportunity that you allow us to reach out to such a large number of people through this platform. Thank you very much.
Thank you, Dhruv, and thank you, Nishith Bhai, for this opportunity. In fact, it was a privilege when Dhruv reached out to me to write a chapter in this book to be brought out as a tribute and a testimonial to the innovation, the kind of passion that Nishith Bhai brings to the fore in his research on international taxation. And I would echo every word of what Dhruv has said. Not only has he been a pioneer in the research on international taxation, his chamber has spawned many a leading illustrious tax juniors who have made a name for themselves in this professional market. Nishith Bhai, hats off to you for all that you've done in your journey. Friends, I have written a chapter on non-discrimination in tax treaty. Today, it's just to whet your appetite. I think we will go into detail when we actually get into the subject on a later date. But this is, I think, a subject which has not been deliberated much, not been used much, but of late, people tend to look at the non-discrimination article in the tax treaty to determine whether or not a tax provision in the domestic statute falls foul of the non-discrimination article. So various paragraphs of Article 24, as part of the OECD Model Convention, is what has been researched and deliberated in my article and supported by judicial precedents in India and overseas with respect to how this article has been interpreted by the court and how we see it going forward. I am sure that in the years ahead, one will see a lot of tests to domestic legislation. For instance, very recently, the Income Tax Appellate Tribunal, a special bench has held that transfer pricing provisions do not violate or do not infringe the non-discrimination article, although I do hold a different view. And I am sure that this will see ultimately winding up its way up to the apex court. And it will be the Supreme Court which will eventually decide whether or not the non-discrimination article would be infringed by the domestic transfer pricing legislation. This is just one example that I thought I would introduce in this limited time that's available to me. Once again, thank you, Nishith Bhai, for giving me this opportunity.
Thank you very much, Mr. Vohra. Could I now please request Bijal to introduce herself and her chapter, please?
Thank you, Dhruv. Good evening, everyone. My absolute pleasure to have the opportunity and a chapter in honor of Nishith Bhai, who has been a true mentor to me. And what better choice of a chapter than really form over substance or substance over form? I've really named it Two to Tango and a dance of form over substance. And for all of you who know Nishith Bhai very well enough, he is definitely a man of complete form and substance. And that is the reason why I felt that I would like to write a chapter on that. And of course, it is a very current, topic in India, wherein in India we've had situations of just judicial gar, and with the entire Vodafone controversy in 2012, along with the Parliament enacting the general anti-abuse provisions effective 2017, there's going to be a total turnover of the manner in which India really looks at transactions, really a transgression of form over substance to a substance over form. So it's going to be an exciting time for professionals, for taxpayers, in the manner in which the entire tax policy as well as structuring is really going to come about. And of course, I would get into the details of what we've really seen and the entire transgression that India has seen when we do have a complete session. Thank you very much, Dhruv. You've put in a lot of effort. And thank you so much, Nishith Bhai, and very happy birthday to you again.
Thank you.
Thank you very much, Bijal. Could I please ask Clive Baxter to introduce himself and his chapter for Nishith?
Yes, thanks, Dhruv. And I'd also like to join the others in congratulating Nishith Bhai on what in Denmark is referred to as a round birthday. And I was very honoured to be asked by Dhruv to contribute a small chapter to this book. And as at least some of you know, I have worked a lot in the Indian tax world over many years. So it's a privilege to join in presenting this book to one of the leading lights of the Indian tax scene. My chapter is about the measures being introduced as a result of the BEPS Action 6 to restrict access to the benefits of tax treaties in to those who are supposed to be getting the benefits, and that's the theme of the chapter. But I've actually used this theme and what has been going on in the latest version of the OECD Model Tax Convention in Article 29, in BEPS Action 6, and in the MLI Article 6 and 7. I've used this as a backdrop to look at what is happening in the world of international tax, and the way I think that we are moving towards more fully fledged public international law of taxation. It's not there yet, but there are certainly signs that this is coming into being, and that's what my chapter discusses. And I'll look forward to saying a bit more about it in a couple of weeks from now. Thanks, Drew.
Thank you very much, Clive. Could I please request Daksha Baxi to introduce herself and her chapter?
Hello, good evening, and thank you, Dhruv, for giving me this opportunity. It's a wonderful opportunity. And I totally agree with everything that you said about Nishith Desai. And it is so amazing because when you said to think of a topic to talk about, I was sort of taken back in time to 2001 when the digital economy transactions were being really looked upon by the entire world, and more importantly by India as something on which India wanted to have a better handle to be able to tax those transactions. And it was an amazing experience that Nishith Desai took upon himself to a virtual group back in 2001 to create scholars, to pull together some scholars around the world to create a report which was such a scholarly report which he presented to the government to say that we do need to look at this very carefully because India should not be singled out and lose on the digital economy participation that India is truly entitled to have. And well, the tax department continues to have its own way of fighting and wanting to tax the transactions, but his report would have certainly made an impact on the not necessarily on the judiciary as per se, but certainly had such a wonderful impact to say that the judiciary was looking at all those aggressive taxing provisions that the tax department was bringing out in terms of true interpretation of international taxation and honoring the tax treaties. And so we have seen India being slightly aggressive, but we have also seen the judiciary and the judicial precedents being much more in favor of the taxpayer. And I would certainly say that this is something that Nishith Desai did contribute, and I was very happy to be part of that group of people. And then we are seeing this entire movement of the BEPS and now coming up the Pillar 1 proposals from the OECD. And my chapter, my essay in this book actually talks about this entire journey that India has seen and the world has seen in terms of how to find a solution to taxing the transactions. And I only want to conclude that we haven't really found a solution, but it seems like people are becoming more and more aware of the fact that whatever be the solution, it needs to be somewhere creating a balance between the growth of digitalization and yet being able to have a fair chance for the jurisdictions which contribute to the growth of digitalization. So that's something I think will be a solution found like that will be a fitting tribute to Nishith Desai for thinking what he thought back in 2001. And I'm truly honored to have this opportunity to do so. Thank you, Nishith Desai. And thank you all for giving this opportunity. And I hope people enjoy the chapter as well as the book, of course. Thank you.
Thank you very much, Daksha. Indeed, your chapter was one of the most riveting ones for me to read. Whilst we are going through this round of introductions, I noticed that Mr. Datar has also joined. And today's session, the content, the substance of it was going to be Mr. Datar's the presentation. And I know that he has time constraints. So may I, without any further ado, please request Mr. Datar to introduce his chapter and explain to us what he's written about. Thank you very much.
Yes. Thank you, Dhruv. And first of all, let me congratulate Nishith Bhai. I want to wish him a happy birthday with retrospective effect. Unfortunately, we could not meet at the function at Alibag. So many happy returns of the day, and I look forward to many more years of contributing to the tax field. I must thank Dhruv and the team for inviting me to contribute a chapter. But anyway, I decided to write on tax and constitutional law. I have in my paper mentioned the important topics of taxation. But as far as today is concerned, I'm really concerned about the limits of parliamentary power to tax non-residents. And I would request those of you who take the time of reading my book, my chapter, we have to seriously reflect upon the limits of extraterritorial taxation. With the significant economic presence coming in, the equalization levy coming in, one has to really examine what extent India can go and tax non-residents. I think we are slowly taking the steps and going beyond what I think will be constitutionally permissible. Because under Article 245, in my personal opinion, Parliament has the power to make a tax which has extraterritorial operations, but it doesn't have the power to make extraterritorial legislation. For example, you can tax something which has a nexus with India, but it is completely impossible or impermissible to tax something which is nothing to do with India. Neither the source is in India, nor the residence of the person is in India. But you can't, by legal fiction, deem that income to be in India. So this is one area which we have to seriously deliberate upon, and the matter will sooner or later come to the Supreme Court. Going back for some time in 1989, in the Electronics Corporation case, Justice Pathak had raised this issue as to what extent you can go to tax the income which have no nexus with India. This was referred to a bench of 5 judges, but unfortunately, Electronic Corporation withdrew their case and nothing really came about it. At present, we only have a very unsatisfactory judgment in the GVK Industries, where it is unfortunate that the Supreme Court went into this question. If you read the judgment, the senior counsel for the petitioner said he doesn't want to get into this issue. He didn't want to discuss that at all. But yet the Supreme Court went and gave a very elaborate judgment without the benefit of arguments from the petitioner or arguments from the revenue in detail as to what is the scope of such taxation. So now if you see the new explanation 2A and explanation 3A on significant economic presence, you're virtually taxing a person in America just because he has issued advertisements targeted at an Indian audience. Some data is collected from India, it is taken abroad and then sold to the first seller or to the second seller. That income also becomes liable to tax. So I'm really worried as to what extent Parliament can go. And I think the matter will come sooner or later to the Supreme Court. The other issue which is bothering me is the reluctance of the courts to interfere where they should, especially where assessments are reopened. And many courts are simply reluctant to get into the matter and use their jurisdiction under Article 226. I hope that there is some kind of understanding by the courts that very often the alternate remedy is really a myth. You can't. I've not seen any case where a 147 proceeding has started and dropped. It always goes right up to the Supreme Court, and then there's little relief for a person to then, at the Supreme Court stage, being told that your case is below 2 crores, therefore we are dropping the proceedings. So that's not a really satisfactory method of doing it. So I've tried to cover all these aspects in my chapter. I've divided the chapter into 8 subparts, which are relevant and on taxation, because at the heart of it, all these powers must be traced to the constitutional provisions, Article 246 to N382. I think this, since Nishith Bhai is more connected with direct taxes, I did not go too much into GST, but there are also certain issues are going to crop up in the role of states versus center on taxation as states face a funds crunch, whether they can levy a parallel GST along with the center. That's another big issue that is going to crop up in the months and years to come. So this is broadly my topic on constitutional law. And I can tell Dhruv, I can stay back for some more time. If there are any questions, I'll be most happy to answer them. Thank you.
Thank you very much, Mr. Datar.
I just intervene for a minute because Arvind has to leave. But
No, I
thank
can
you
stay for 15 minutes more.
Yeah,
I can
okay.
stay for 15 minutes more, yeah.
Yeah, so okay, so because I know that you're working on Palkiola's book at this point in time.
Yes.
And you're almost about to finish, and you got ramped, so you're going to be back with us a little later in next week or something like that. But I really want to thank you. And I also recall my days in 1977 when I worked on Palkiola's 7th edition. And if you read the preface those days, there's one sentence which Palkiola wanted very much to be in the preface to say that how many amendments, deletions, omissions have happened. So I had to physically take all the amendments from 1961 until almost 1977, count them physically, where the word deletion there, and that was all the cases I had to recheck and all that thing. So I learned so much, and so it is nostalgic for me, and I'm so happy that somebody is taking forward his legacy, and nobody who better than you know. So I don't want to.
So thank you for the kind words. Thank you so much, and I look forward to the inputs from all your colleagues who will help us in writing this book. Thank you so much.
Yes. Thank you, and I think I'm going to be talking lastly about One World, One Tax, my vision, because you're going to go, but we'll talk separately about it.
Talk to you.
At the moment, let us hear. All my colleagues and friends have come together, so I don't know, take away the time, but because you are going to leave soon, I thought I'll just make a comment.
Thank you. Goodbye. All the best. All the best.
Thank you, Mr. Datar, very much.
Thank you.
If
there are any questions, you can just send them to me. I'll try to answer them. Or next week, sometime I'll come on a session and I'll reply.
All right. So you're not taking any questions right now. We'll take them later on.
Yeah, whatever suits you. Yeah, fine. All right. Okay. Thanks a lot.
Sure. Okay. Thank you very much. Bye-bye.
Bye-bye.
So with that, I think we can get back to the introduction of the authors and their chapters. May I now request? I do not know if Professor Rosenbloom is still online. I don't think. I think he is. Professor Rosenbloom, would you mind very much to introduce your chapter?
I'm happy to do that. Can you hear me?
Yes, very much. Thank you very much.
So congratulations to Nishith, whom I've known for many years. I had the pleasure of teaching a course to his firm at one point. It was a pleasure to be, an honor to be asked, and a pleasure to do the article that I did. I wrote on a somewhat disparate topic. I don't think anybody else is in the same area that I wrote on. I discussed the use of bilateral investment treaties to resolve tax disputes. And India has been at the forefront of that. They've been involved in a number of very high-profile bilateral investment arbitrations. And my chapter deals with, my reaction to being actually involved in one of those arbitrations as a witness on behalf of the Republic of India. And frankly, I was appalled. I thought that as a means of resolving tax disputes, I think bilateral investment treaties are about as bad an idea as I can conceive of. It's hard to imagine anything much worse as a way of resolving a decision. They're inefficient, expensive, lengthy. I was astonished. I was in an arbitration room where there must have been 60 people present. I would say 58 of them didn't know the first thing about taxation. And putting tax issues before an arbitration panel raises lots and lots of problems. I did not go into all of them in my chapter, but when I do have a chance to talk, I will make some suggestions. I am very strongly of the view that the world has got to reinforce the strength of tax treaties, and particularly the mutual agreement procedure. And the only way to do that, in my direct experience, is by moving into a world of mandatory arbitration. And I just don't understand the idea of a country that is willing to go into a bilateral investment treaty, but is not willing to go into a mandatory arbitration. It just doesn't make any sense to me. So I'll be very happy to talk at greater length when it's my turn. But I am deeply, deeply skeptical about bilateral investment treaties as a means of getting a satisfactory resolution of tax disputes. Thank you for your attention.
Thank you very much, Professor. I read your chapter with wonder, because I found most of the things that you said very, very agreeable. And I'm pretty sure that our audience would very much like to hear you speak in more detail about this topic. One of the aspects about what has gone on in the book is that it's not always, I mean, I do know that to some extent there might be an academic disagreement between Professor Rosenbloom and what Mr. Desai might feel about this topic. But that is the majesty of academia and free thought, that one can still write on a topic which one disagrees with what one's views might be, and yet be in that person's honor. So thank you very much for writing this chapter. I enjoyed reading it very much, and I look forward to hearing more about it from you.
Delighted.
Having said that, may I please now request Mr. Dinesh Kanabar to introduce his chapter.
Thank you, Dhruv, and it's a pleasure and honor to be in this august audience. And I must reminisce about my first interaction with Nishith. I'm not too sure whether he will remember it, but I used to work in this, I was a partner in this firm known as Ratan Mama and Company, and I started the practice of international tax there. And Mr. Mama said that, look, if we have to start a practice of international tax, the one person you should meet is Nishith. And I remember meeting Nishith probably somewhere in late 80s, early 90s. There I was sitting in his office, and Nishith is talking about his experiences, about how he's trying to create a firm in India, a la Wachtell Lipton, whom I had not heard about at that point of time. And since then, it's just been a pleasure, a joy, and a privilege to see how Nishith has grown and contributed to the field of international taxes in India, including the work that he has done on digital taxes. And more important, I've seen how there is no other firm in this country which invests in research as much as he does. The number of programs that he's doing during this lockdown period is quite amazing, has been a source of inspiration for us. And I know how many of my colleagues participate and have rave reviews to what Nishith you have been during this lockdown period. So thank you for that. Coming to my chapter, we're talking about treaty abuse, and more important in the context of multilateral instrument. So as Bijal spoke about, we begin our chapter to talk about form and substance, but then quickly move on to say that we have always debated form and substance, but now, thanks to the MLI, we have the concept of principal purpose test. And principal purpose test goes far, far beyond substance, goes to the root of how treaties are likely to be interpreted in times to come. And then we go on to examine some of the instances, case studies which have been given by OECD in the context of what this would mean in India. And more important, we have gone on to examine as to whether when India has grandfathered some of the provisions of general entity avoidance regulations, will the principal purpose test stack up, and will that also be covered by the grandfathering provisions, or will we need to look at the treaties anew? So happy to discuss this at length when we discuss the topic at length. But again, it's a privilege to be contributing to this book, and I'm honored to be part of the whole exercise.
Thank you very much, Mr. Kanabar.
Dinesh, I still remember those days very well. In the early advanced ruling, we worked together, and it was very good, I think. David, thank you so much for your being here as well. It's very nostalgic, and thank you. Carry on. They'll continue.
Thank you very much. May I now please call upon Professor Guglielmo Maisto from Milan in the midst of the lockdown to please share an introductory summary of his chapter.
Thank you. So also from my side, congratulations to Nishith for your birthday and congratulations for your career, what you did. And thank you for inviting me to this session and to the coming panel discussions that we shall have. Also, my paper deals with reflections on Pillar 1, the paper presented by the OECD, and particularly I'm focusing on the domestic tax ramifications of that particular approach and document, which obviously requires attention in several directions. First of all, is not only addressing the digital economy. We believe the Pillar 1 does include a reference to the debate of source tax versus residence taxation, and the issues I raise in connection with domestic law and the ways Pillar 1 might be introduced into domestic legislation has to do with a number of factors. First of all, taxable persons in all countries or in most jurisdictions, we do need to identify taxable persons, which is something which Pillar 1 OECD document doesn't seem to address, as it refers to multinational companies, so to group entities. So that is one of the issues that domestic law of several countries should have to address. A second issue has to do with excluded businesses. For some businesses, there might be reasons to be excluded. The OECD makes a reference actually to have a Pillar 1 to cover solely businesses facing consumers that might raise constitutional problems in several countries, to discriminate and have one business to be covered and others not to be covered by territoriality rules, which may change, and a few other issues which have to do with thresholds and also losses and the application, the determination of a taxable base. I believe that the subject is a good topic for a debate because of two recent developments. So the first one is the US reaction to it. Pretty recently, the US reacted to Pillar 1, making a reference to something which would not be mandatory, but will be rather to be used as a safe harbor. And second, the point that this emergency that we are facing might make it important for us to address, namely how we can avoid source taxation, especially in the world in which working at distance, smart working and so on, might make the problem becoming more acute in the future if this emergency might really determine a change of business models. So that's basically the subject. So thank you again for inviting me to this event, and congratulations again to Nishith Desai.
Thank you, Guglielmo. Wonderful to have you here. Thank you so much for your solution and contribution. Dhruv, over to you again.
Thank you very much, Professor Maisto. May I now please call upon Meyyappan, who co-authored his chapter with Nehal Binani, to introduce his paper.
Thank you very much, Dhruv, for all your effort in putting this together and making this happen. My chapter in the book, I think, is something different from what the other panelists may have written upon. It's also reflective of Nishith Desai in the way that I think many of them have known him for years and as the international tax expert. But there are, I wanted to highlight through the chapter also other interests that Nishith Desai has. And recently he's been saying that we need to use legal scholarship for making the world a better place. And several years back, he was one of the first to set up the social sector practice. So the chapter that we have authored is at the intersection between tax laws and philanthropy. So the chapter is focusing on impact investment. So an impact investment is something that parties undertake with not just financial returns in mind, but also social returns or other outcomes that they wish to achieve through their investments. So the idea was to use tax policy as a tool and see how we can make this more better in the current ecosystem in India. The present laws don't allow for philanthropic money to flow freely between or intermix with private capital. So there are several restrictions there. We looked at international studies, and we also looked at how there are innovative models for deploying finance around the world, and we have looked at how a sliding scale tax incentive or other measures can be used to make this more easily doable in India. It comes with a lot of benefits in terms of, and it's probably the need of the hour in this sort of a situation where people are looking not just at financial returns, but also looking at having other non-financial impact in the market.
Thank you, Meyyappan. I think you've done a wonderful job on the social sector side, and I'm thankful to you for contributing, and Nehal too, for in the chapter writing. Thanks a lot.
Thank you, Mayor, and thank you, Nishith Desai. May I please now request Mukesh Bhutani to please introduce his chapter.
Thank you, Dhruv, for introduction. Firstly, little small word about Nishith Desai. Thank you for inviting me. When I started my career as a newly qualified chartered accountant, I recall that the only book that was available dealing with non-resident taxation was a book on NRIs, in which Nishith Desai had comprehensively analyzed what used to be in those days the FERA law, the foreign exchange before the FEMA law of 1973. And it comprehensively analyzed a lot of provisions or very few provisions that were there in the Income Tax Act. I still have a copy of that, Nishith Desai, in my residence in Mumbai. And I cherish that because I learned my first lessons on international tax reading your book. I still recall it is the 1983 edition of that book. So thank you for inviting me, and wish you one more time a very belated happy birthday, and wish you lots of success. What I have written on is an essay on deconstructing the principal purpose test under Article 7 of the MLI. But before we get to trying to deconstruct the PPT test under the MLI, we have looked into what are the issues that are arising out of Action 6, because it is Action 6 which gave birth to the MLI document. And just as a background, Action 6 deals essentially with two kinds of issues. The type 1 issues, as we call it, are persons attempting to circumvent limitations provided by the treaty itself. Say, for example, a limitation on benefits clause. Then the Article 6 also provides with type 2 kinds of treaty circumvention. It says persons who are attempting to circumvent the provisions of domestic law using treaty benefits. Now, this is an extremely tricky part of type 2 in Action 6, particularly if you read with the Indian income tax law. So the PPT rule then, which is embodied in Article 7, how does it align with the newly Article 29(9) of the commentary of 2017 Model Convention is something that we have comprehensively dealt with. While dealing with that, we have also drawn a contrast with the 2014 Model Convention, how the 2017 Convention differed from it. My contribution is perhaps deliberating on some of these issues. Now, what does really the session that we are going to have essentially cover? It's going to cover what is India's outlook on MLI, which has come into force from October 1, 2019, and how it in the context of key double tax treaties. In its final position, as we all know, India has clarified to opt for the principal purpose test and the simplified LOB, with its intention to adopt the LOB provision in addition or in replacement principal purpose test. And that, of course, would be subject to the bilateral negotiations that India may have with some of its treaty tax partners. We all know that it is undisputed that the MLI coming into force has very wide ramifications on how the PPT will apply. So my session will also focus on the background and the basic design of the principal purpose test. Issues like what is the default option, how do you opt-in provisions, what are the various reservations, and what are the notification clauses. And then we will proceed to explain the subjective and objective elements of the principal purpose test and how they will have to be interpreted in light of prevailing jurisprudence, which is very limited, but we have tried to look into other forms of interpretative aids that are arising out of the OECD commentaries or the Vienna Convention on Law of Treaties, or for that matter, any other explanatory statement. One of the important aspects of the session will also be to focus on the interplay of principal purpose test with the domestic guard provision and how they can be invoked, looking at the exception clause envisaged again under Article 7 of the MLI. And then in the concluding parts, we will shed some light on procedural aspect, such as the standard of reasonableness, implementation challenges as we see insofar as the PPT is concerned, and a very broad and arbitrary nature in which we feel there are risks that the revenue may invoke, and some of the questions on the constitutionality, which Arvind Datar sir also spoke about earlier in the session. So thank you very much, Nishith Bhai. Thank you, Dhruv, for inviting me. And I'm looking forward to joining everyone to listen to some excellent analysis that all the authors have done.
Thank you, Mukesh, for fondly keeping my book. It's so nice of you. I still remember you are one of the bright talents at Anderson, and I had an occasion to come and give some talks those days. So forgettable days. So thank you so much. Thank you for contribution.
Thank you, Nishith Bhai.
Thank you very much, Mr. Bhutani. May I now call upon Radhakishan Rawal to please introduce his.
Thanks, Dhruv. And before I talk about what I've written, I want to say something about Nishith Bhai. Nishith Bhai certainly has been, kind of a very inspiring figure for all of us, in the area of international taxation. So in that sense, it's a real honor and privilege, to get associated with this project. I never worked with Nishith Bhai as such, but in the very beginning of my my initial foundation years, so to say, had to start international taxation with one of the ARs, which Nishith Bhai has got in favor. Very interesting AR, insurance companies, getting income from trading on Indian securities. And Nishith Bhai, you would certainly remember the AR. But that was a really interesting AR, which we had to apply, and a lot of our clients, and a lot of the learnings, a lot of the initial shaping, about international taxation did happen, from there. So it's really a good learning experience. And thereafter, once you read something like this in initial years, you can't, afford to miss the, the emails which you get, from Nishith Bhai's office, about a lot of the knowledge sharing articles, which keeps coming. So, it has been a pleasure. Nishith Bhai is really towering personality, like a father figure for a lot of us. So Nishith Bhai, that's a very good experience. Just to talk about my chapter, my chapter, I have focused on the changes to the domestic law, as a consequence of BEPS. So BEPS project, as you know, is implemented in 2 or 3 manners. Amendment to the model, amendment to the existing tax treaties, which is happening through MLI, and then the corresponding changes which are happening in the domestic law. In my chapter, I have covered two parts of it. One is significant economic presence. When I wrote, it was in explanation 2A. In the old Avatar, in Finance Act 2020, kind of takes it away and reintroduce it, with some minor changes here and there. So, that's one area which I have analyzed. I have also analyzed another explanation in section 9 dealing with agency P, which is also in consequence of BEPS project. Very interestingly, I'm looking forward to the session, at which I have to present, and I'm going to talk, something about, a new concept which is coming up, which is intangible business connection due to down the line publicity. Very interesting tribunal ruling which has come recently. So I'll deal with that. I'll deal with explanation 2A, 3A, and look forward to interaction, in the sessions to come. Back to you. Thanks.
Thank you very much, RK.
Radhakishan, so nice of you. I've seen you growing up from day one almost, although we interacted in that insurance company's case. I think everything that together we have done is something different, unique, and landmark. So it's very nice of you to remember those things. Thank you.
Thank you very much, RK. And may I please now, we're running out of time, so I would like to introduce Shefali. We're actually right in time. Shefali Goradia, could you please introduce your chapter?
Thank you, Dhruv. Hi, everyone. And Nishith Desai, happy birthday to you. When Dhruv called in asking and inviting us to write, we didn't have to think twice. I think this is one of the best birthday gifts we could have ever given you. And it's nice because, many of us and, many of our authors, right, some of them are current colleagues, some are ex-colleagues, but we've all grown up together in the world of international tax. And we are all proud to say that, our interactions with Nishith Desai has been quite enriching. And you've been truly a mentor and guru for us. So we are really happy to do this for you. Coming to my chapter, I have written on fiscally transparent entities. And as RK mentioned, I think my memory of this also goes back to an early ruling before the advanced ruling authorities that we had all worked on, while I was at NDA. And it related to a pension trust and, its tax transparency and whether it should be treated as a resident. Should it be treated as a person, and whether should it be treated as liable to tax, and therefore should it be entitled to the treaty benefit or not? And since then, we've got a lot of rulings now in India. Of course, globally, there have been many rulings. A lot of academic work has been done on this. We've seen OECD commentaries as well as the drafts and many of the other tax treaties which now expressly grant treaty benefits to the fiscally transparent entities. But at the same time, the law is not very clear in many countries, including in India. And I find it very fascinating, how the courts approach this subject at different points in time. Sometimes they give due weightage to the nature of entity, and sometimes they ignore the form and look at only the substance part, which is about taxability of the income of that entity. And that's what I focused on in my chapter. And I have written a comparative of how the different courts have approached this subject and what India should be looking at going forward. And I'm really looking forward to discussing this on our session on Wednesday. Thank you.
Thank you very much, Shefali.
Thank you, Shefali, I think, for wonderful words. Really appreciate your coming on board and writing a great chapter. Thank you.
Thank you very much. And lastly, I would like to also introduce my chapter very, very briefly. Like Shefali, I have also written on hybrid entities. I can already see Radhakishan smiling about it because I've been going on and on about hybrid entities for the last few years now in dealing with Article 1, Paragraph 2, which has now been introduced under the BEPS project in both the OECD as well as the United Nations model. And basically, Article 1.2 is a codification of what was written in the Partnerships Report of 1999. What they have done essentially is they have the two mantras that come out of it, that insofar as attribution of income to a person is concerned, then the source country must follow the residence country. But insofar as the characterization of income is concerned, the residence country ought to follow the source country. What Article 1.2 ends up doing, however, it only codifies one part of it, where it says the source country should follow the attribution rules of the residence country. And this partial codification of what the partnerships report did leads to several issues. And my chapter deals with what these issues are, how one could overcome these loopholes. I will leave it at that because day after tomorrow, Shefali and I are going to be presenting our papers in more detail than this. But with this, I hope that we have given a fair understanding of how diverse the book is and how in-depth the research is in various topics which are pertinent to international tax law. And I really hope that everybody who has come out to listen to this webcast has got an understanding of it, and I look forward to seeing them again.
Words here, Dhruv, thank you.
Yes, please.
Okay, so I think now let me take my turn and hope all of you will be a little patient to listen to me. I think for me, the journey of international tax began sometime in 1977 when I did my LLM, and it was with international business transactions, my specialization. But at that point of time, nobody had studied tax implications of international business transactions, and I thought I'll do PhD. And I tried to go to university and find somebody who could, work on this. I found there was no professor, nobody else, and they said it may take 2 years. And then I thought that, okay, let me do my own private research, and I started doing all the different studies, comparative law studies and stuff like that. And then I stumbled on something which today is called international tax. So originally, my thesis was, was a taxation of international business transactions. I think that is how it was. But then it turned out to be international tax. And in 1981, I got an opportunity to, do work for a company called Baxter, which again is one of the famous rulings. Later on in 90s, it happened. But, and so it journey went on. But it is so fascinating that, and I always believed that the geography will be history one day. I think we'll go more and more borderless, and I think that will become one some way or the other. And today, as far as technology is concerned, I think it has become a borderless world. And one of the desires that I've been talking for the last 5-6 years is, can we think of one world, one tax? Because today, everything, all boundaries are so much blurred that it's very difficult to say that, where is the source, where is the income, even where is the residence will become an issue. Because where your body is or whether it is, where is your heart, so it's form over substance. And, things like that. In the process, we'll have, for example, technologies such as augmented realities, virtual realities, and you will be able to remain present in 2 or 3 or more places at the same time. Now, where will you be residing, effectively speaking, And of course, in India, everything is a dimming fiction, if you see majority of the tax law is dimming fiction, and you can dim anything and everything so long as you can tax it. So we'll have to move towards this concept of one world, one tax willy-nilly. Some progress is already happening in Europe, but I believe that, why do you want us to be bothered with, like, if I'm a large company or operating in different countries, why should I be bothered with tax department? Okay, world come together, all the governments like United Nations, you come together and tell me how much tax you want. Okay, you want 15%. How do you want to, what is the formula for taxation? I'll put it in escrow account and you countries figure out how to distribute the revenue between yourself. Why do you bother me to fight cases in n number of countries, 100 countries around the world? So I think we'll talk about it at some point in time. But one of the things I'm very keen on working on and doing some research is on one world, one tax. Can we, do that? Of course, the question mark always remains, and Dhruv has his own views and we have own things. I think all of you are welcome to join in this project. Let's, because ultimately it's going to be one world. And if we think on those terms, maybe we'll have some better solution than trying to, attribute source to one country and attribute residency to other country and stuff like that and whatnot. I don't want to get into details at this point in time, but that is one of the things I really want. I honestly want to thank everyone who has contributed to this chapter and otherwise joined for this discussion today. We'll be talking about each of the chapters in more detail as we move forward in the next 2 weeks. So look forward to seeing you all in next sessions. Next one will be, I think, on Wednesday and Friday and so on and so forth. You already have a schedule. Most welcome. It is going to be very exciting because you'll find many more interesting people talking to you than what I'm talking right now. So sayonara in the meeting.